This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about why stealing from a fellow church member can be costly, and a debt resulting from fraud is not dischargeable in bankruptcy. A knowing misappropriation and conversion of funds is fraud. In a case entitled In Re Matthew Jene Tubbs, the bankruptcy court in the Northern District of Texas on October 15, 2025, dealt with the claim of a fraud that was not dischargeable in bankruptcy. Plaintiffs Robles and Defendant Tubbs met through their church. Both held leadership roles. In February 2021, Robles' home suffered major water damage from Winter Storm Uri, and insurance paid them $173,000. In the fall of 2021, Tubbs represented to Mr. Robles that he personally built a newer house and large barn on his parents' property with his own hands, except the foundations and insulation, that he had 10 years' experience overseeing window door installation in a major home improvement chain, and was a licensed contractor and carried general contractor liability insurance, both of which statements were false. Relying on these representations and Tubbs' church handyman work, Robles hired Tubbs as general contractor for insurance repairs and upgrades, even though Tubbs had no prior general contracting experience. The parties did not enter into a formal written contract. Instead, the parties jointly created a detailed budget spreadsheet, labor plus materials by room, and an 8 to 9 week timetable, later revised to the end of February of 2022. Plaintiffs advanced $216,000 to Tubbs, and Tubbs made almost no meaningful progress by August of 2022 and was fired. Most items on the spreadsheet were never started. Flooring and kitchen cabinets he did not start, or did start, were defective and had to be redone. Tubbs failed to buy most of the materials despite having the funds and could not account for the money. Tubbs admitted on June 10, 2022, quote, "I do not have the money to finish the project right now," close quote. Tubbs admitted he used project funds for personal expenses, a floor sander for $5,000, of personal credit card bills over $8,581. Tubbs claimed he paid himself $78,000 as a legitimate general contractor and overhead at $10,000 a month. The court rejected this as not credible and unsupported by the spreadsheet or the timeline. Tubbs raised numerous defenses: undue influence by the church authority, insurance fraud by the plaintiffs, and no binding contract. The trust fund defense, illegality and unclean hands, mistakes, statute of frauds, etc., all of which were not really convincing to the court. The court found that Tubbs made 3 material false representations that induced plaintiffs to hire him and advance funds in violation of Section 523A2A, false pretenses. He claimed he built the house and barn himself. He was a licensed contractor and he carried GC, general contractor liability insurance, none of which was true. The court concluded that the plaintiffs justifiably relied on these representations and rejected Tubbs' puffery argument. The entire $152,610.05 debt was found to be non-dischargeable on this ground alone. The court did not need to reach a finding of actual fraud. Section 523A6, willful and malicious injury, is also non-dischargeable, and the statute requires deliberate, intentional injury, not just intentional act or objective substantial certainty of harm, plus subjective notice or intent to cause the actual injury. Tubbs, knowing misappropriation of funds of at least $152,610.05 of project funds for personal use, while knowingly leaving the job incomplete, constituted willful and malicious injury to the plaintiff's property. Contract debts can be non-dischargeable under Section 523A6 when the breach conversion is intentional and harmful. The court also overruled all of Tubbs' defenses because there was no undue church influence. There was no insurance fraud or unclean hands by the plaintiffs. The valid oral contract existed, and Texas Property Code Section 162.031B trust fund defense was inapplicable because the $78,000 was not legitimately spent on the project or a reasonable overhead general contractor's fee. In conclusion, the bankruptcy court entered a non-dischargeable judgment of $152,610.05 against debtor Matthew Tubbs in favor of the Robles, based on false representations that induced the contract and willful malicious conversion of construction funds. Tubbs' numerous defenses were rejected as not credible or legally unsupported. So there was a judgment for the plaintiffs, Felipe and Shireen Robles, in the amount of $152,610.05, declared undischargeable in Tubbs' Chapter 7 bankruptcy, and the finding of willful and malicious injury stood. In my opinion, the availability of a great deal of insurance money creates a temptation to even honest church-going people. Mr. Tubbs was more than tempted. He lied about his abilities and took the insurance money designated to repair the home of the Robles and used it to pay off his ongoing debts, and then filed bankruptcy, hoping to avoid paying back what he owed. The bankruptcy court found that he defrauded the Robles and could not discharge his debt, and he's very lucky he's not going to jail for that fraud. This video is adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog and these videos on YouTube and rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.